About 9 minutes gone past 5. You're still listening to Hard Facts in 92.3 Nigeria Info. I am yours truly, Kaladakoru. Batubo. Conversation continues right about now, and we want to look at one of the biggest stories in town for today, and it has to do with the Supreme Court's interpretation of what happened or transpired, during the state of emergency, or what we, term as an illegal state of emergency. The Supreme Court has opined. Now, I'm using the word opinion interpretation because, they said they do not have jurisdiction, they do not have, the capacity to take the matter, but if they were to give their opinion that, the president was within his right to have not only declared the state of emergency, but suspended the arms of government that were suspended, as the executive and the legislative arms. To help me have this conversation for the short period that we have is another lawyer and a public affairs analyst based here in Rivers. And he is a regular. I would say while I was on the show, he was a regular because every one time or almost every one time I had a legal matter, I would call him on the show. I'm talking about God's Power Egbule Esquire. God's Power, welcome on the show. It's good to have you.
Mr. Kaladakoru, it's been a long while, but it's my pleasure being here.
All right.
How are you doing?
I'm doing great. I'm doing fantastic. Let's get straight into the matter that has got us here. That is the Supreme Court's interpretation. Now, what do we call this? Do we call this a judgment, an opinion, an advice? What do we call this?
Well, it's a judgment, but because the case was struck out, every opinion that the Supreme Court has expressed will not have any effect, and that's because the Supreme Court struck out the matter. The Supreme Court struck out the matter because the plaintiffs, in the wisdom of the Supreme Court, didn't have the good standard to institute the matter. So even if one finds it a bit plausible that the Supreme Court had said Section 305 does not put the president with the powers, to destabilize democratic structures, even if he has a power to declare a state of emergency. As plausible as that pronouncement is, it will not have any effect because the matter was struck out.
So is it that the matter was struck out, or is it a matter of jurisdiction? Because we've had different analysis, we've had different people talk about. I mean, some lawyers say jurisdiction. Now you say the matter was struck out, which is
the matter was struck out. The matter was struck out because the court said it didn't have jurisdiction.
Oh, okay.
If we take a look at Section 3232 of the Constitution, the Supreme Court has jurisdiction to entertain a matter between states or between states and the federal government. But in this instance, the Supreme Court is saying that even if it has jurisdiction to entertain a matter between states, the subject matter, the states that brought the subject matter didn't have any interest in the matter. Jurisprudentially, that may be argued. But what the Supreme Court said was that Rivers State was not a part of the plaintiffs. But it leaves us asking a very jurisprudential question, which is, in the light of the fact that democratic structures, were
dismantled for a time.
Were dismantled. Thank you for the choice of word. Were dismantled. How would Rivers State be part of that? Be part of the suit?
Interesting.
So for some of us who are constitutional lawyers, who have made a lot of research in this particular area of law, what we're thinking that the Supreme Court would have taken this opportunity to have decided conclusively on this kind of matter. Remember that we had this kind of situation in 2004, and what happened in Plateau State, the matter too was struck out, and the matter was struck out because the Supreme Court also said those who brought the matter didn't have the authorization of the Plateau State government to brought the matter. But when democratic structures are dismantled, who gives such power? Who gives such authorization?
Okay. It's interesting you brought this up. Setting key terms, locus, jurisdiction, struck out. And this, because the Supreme Court went ahead to give his opinion. Can this judgment, like you called it, or opinion, like I prefer, be referenced in future legal matters? Let's say in 2040 something, a governor or a president Canada decides to suspend a governor Canada. Can the governor Canada, take the president Canada to court and say that's an illegal, can it be referenced? And Supreme Court had said during President Tinubu's time that he has the right, to suspend a governor and the lawmakers in that state.
Okay, when you take a look at what we call judicial precedent, which is the judgment of the Supreme Court binds other courts, but it must be the judgment of the court matter is not struck out in this particular instance. But be that as it may, the opinion that the Supreme Court has given in this matter should be conclusive to the extent that no other president should dismantle democratic structures with the state of emergency. But the challenge I have is that politicians in Nigeria always err on the side of breach, and another politician may just stand up on it and still dismantle democratic structures, push the declaration of state of emergency, and tell you that the Supreme Court has not made any pronouncement. Now, there's no difference between what the Supreme Court said yesterday and what the Supreme Court said in 2004.
Are you serious? So let's get to it. What did the Supreme Court really say? Because too many interpretations. What did the Supreme Court really say?
There were a lot of issues that the Supreme Court dealt with, but you see, what was even the main crux of the matter was the preliminary objection filed by the federal government, wherein the Supreme Court said that although the president has a power to declare a state of emergency, but that the president does not have the power to dismantle democratic structures. And the Supreme Court made some comprehensive analysis with the constitution of India and that of Pakistan, and made a little analysis of a difference. Whereas the Pakistani constitution and the Indian constitution allows the president to dismantle democratic structure when the state of emergency is established or proclaimed, that of Nigeria, Section 305 does not give the president the liberty or the power to dismantle democratic structures. But like I said, politicians in Nigeria always to flout decisions like this, especially when they tell you that a matter that is struck out means the matter was not decided on the merits. So if a matter is not decided on merits, despite how plausible the pronouncement is, that judgment does not have any effect. But if we're actually democratic people, if we're politicians who want to practice democracy, what the Supreme Court has done is to give you a hint. And that hint is, in the event that we have the opportunity of determining this matter on the merit, this is going to be our judgment. That's exactly what is.
Okay, so from what a lot of print news platforms are reporting on their websites and even their newspapers, they have said that the Supreme Court alluded to extraordinary measures, and that in the sense gave the president the right to evacuate or evict the governor and his lawmakers from office.
Well, yeah, the Supreme Court did allude to the fact that the president can deploy extraordinary measures during the declaration of state of emergency, but the Supreme Court limited that to the point that the president does not have the right to dismantle democratic structures. So any news report contrary to this is not a decision of the Supreme Court. The Supreme Court didn't say that the president has the right to dismantle democratic structures. But I am saying that there is no the Supreme Court has done now, and what the Supreme Court has did in 2004. I mean, for us, we were expecting that the Supreme Court will look, beyond this technical approach to local standard, to begin to give a liberal interpretation, where what affects one state may likely affect another state. It happened in Plateau, it happened in Ekiti, and it has happened in River State. At what point will the Supreme Court have the opportunity of determining this matter on merit when democratic structures are dismantled? Those who are supposed to institute the institute now lack even the power to institute suits. So who is going to fine?
Okay,
Are
so
you expecting? Are you expecting the military administrator or the administrator by the president to now go to Supreme Court? Of course, no. And the Supreme Court does not have jurisdiction over the person. So if the governor or the speaker or members of the House of Assembly or the deputy governor were removed from office, they become private individuals, and the Supreme Court does not have jurisdiction over them.
okay,
So for me, I had thought that the Supreme Court would have used this opportunity to have given this decision, made this decision, looked at this matter on merits.
okay. Can I ask you a question? So, based on your argument, can we say that from what the Supreme Court attempted to explain, even though you said there is no enough clarity, can we then argue that the Supreme Court actually declared it illegal to suspended Governor Fubara and Martin Ameule and others?
If you take the opinion of the Supreme Court inside, then I would answer the questions, because the Supreme Court actually said, even if that opinion of the Supreme Court is not in contest, the Supreme Court didn't say it in contest with respect to what happened in the state. The Supreme Court gave a general opinion. But if you take that general opinion and contextualize it, what the Supreme Court has said is that the president doesn't have the power to dismantle democratic structures.
Okay, all right. Now let's get to that because I think what the newspapers and websites have been reporting is that the Supreme Court gave the federal government some discretional powers. You know what? Do it according to your discretion. Yet again, we're back to extraordinary measures. That phrase. So you've also agreed that the Supreme Court alluded to the fact that the president has got extraordinary measures as powers that he can exercise in a state of emergency. However, it is according to his discretion. So, what does it mean in your own interpretation?
What it means is that, first of all, we need to take a look at the jurisprudence of a state of emergency. It means that some constitutional provisions will be set aside. That's what it means to go on. But what the Supreme Court has said, why you are setting aside those constitutional provisions? For instance, if you have a state of emergency, you can have a situation where you are told don't come out from 6 a.m. to 6 p.m. That's an extraordinary measure. Naturally, in a democratic setting, you will do that. But because you have a state of emergency, you can tell people don't come out between 6 a.m. and 6 p.m. And the person will not now go to court to say, oh, you're infringing on my rights to freedom of movement. That's because we now have an extraordinary measure. But the Supreme Court said that extraordinary measure must not fail to dismantling democratic structures at the subnational government, which includes the state house of assembly, the governor, and indeed the elected local convention.
So this has become even more confusing because if it's not as clear as it should be, like you've said, there is a possibility that another politician would want to do, and then say go to court and argue with the courts. Is there any way we can have this revised? Because we say the Supreme Court is the court of finality. Is there any way this can be revised?
The challenge is this kind of situation will need to recall for the Supreme Court to sit on this kind of matter again. Happening court technically avoided 2025. The Supreme Court technically avoided the question until disputes like this arise again in the future. The Supreme Court will not be competent enough to make a pronouncement on this. So we will need a situation like this, and I'm sure nobody will pay for this kind of situation. But this kind of situation will need to arise again in the future for the Supreme Court to give a definite pronouncement on this.
Do you think the lack of clarity is symptom to some kind of fear by the judiciary for the executive? I know the judiciary is your work field. It's your farmland, so to say, is where you farm. But I mean, going by what has happened, even in your explanation and understanding, you've said there is a lack of clarity, and there should have been. Could this be a symptom? There's a talk about one party states, power consolidation. We get these conversations every now and then. Could this just be another, pointer to that fact?
Well, what I can say is that by virtue of Section 36 and the determination of anybody's civil rights and liabilities, the court it should run should be a court that has independence and impartiality. So there's
Okay.
an assumption that the Supreme Court is independent and impartial.
Okay.
But I may not know whether the decision of the Supreme Court may have been influenced by extraneous factors. I do not know. But what I would say is, jurisprudentially speaking, the Supreme Court allowed technical justice to provide liberal interpretation of Section 305. That's the best I can say.
Okay.
It's an exercise of discretion. So they have chosen to take this path. Some of us had thought that the Supreme Court would have taken this other path where we have a liberal interpretation of this so that it doesn't happen again. We don't have to experience a state of emergency for us to know whether declaration of state of emergency is right or wrong. The Supreme Court ought to have just entertained that matter, even if it's from the other state. Like I said before, when you dismantle democratic structure, who is going to sue?
All right. I do have a commercial break, a long one at that, so I would reestablish connection in a few minutes' time. So please don't go too far. I'll be right back with you. All right, 5:34 p.m. You're still listening to Hard Facts. I am Kaladakoru Batubo, and with me on the conversation, or having this conversation, or to help me have this conversation, I think that's the best way to put it, is Gospel Igbule, Esquire, Rivers-based lawyer and public affairs analyst. It's good to have you, Barrister Igbule.
Always my pleasure, Mr. Kala.
All right, so I had to take a look at our conversation again. And then, it struck me that your argument saying the Supreme Court, or rather the federal government during a state of emergency cannot suspend them or cannot suspend democratic structures was argued by one dissenting judge, while five others had said, you know what, the president has got discretionary powers. So how do you explain that? Because when in a six-member panel, the 5-1, one would like to think the majority carries the day, and so that means the Supreme Court has actually said, and like the newspapers have reported, that the president can suspend governors.
Well, like I said before, that's not what the Supreme Court said. The Supreme Court actually said that the president has the power to declare a state of emergency, which must comply strictly with the provisions of Section 305 of the Constitution, inclusive of the procedure adopted by members of the National Assembly in endorsing that declaration. It must their rules must be strictly followed. But there's a dissenting judgment. That dissenting judgment is not in public view at the moment. So nobody may be able to tell you the basis for the dissenting judgment, but I may be able to hazard that the dissenting judgment may have taken the part that the Supreme Court actually had jurisdiction to determine this matter. I haven't seen it, but I would wish to hazard that may be the basis of the dissenting judgment.
Okay.
Because the majority decision of the Supreme Court is saying that they don't have jurisdiction to determine the matter, even if they get an opinion as to when the president can declare a state of emergency, and the fact that the president does not have the power as such to dismantle democratic structures. So the dissenting judgment is what we may be able to hazard, which I've just said. Maybe the Supreme Court really had the jurisdiction to determine the matter, which means that the dissenting judgment may have given a liberal interpretation to the issue of local standing, because that's the fulcrum of why the Supreme Court struck out the matter. The fact that these states were not affected by that state of emergency, by virtue of it, they don't have any personal interest in the matter.
Okay. All right. I'm going to open the phone lines, and I'm going to allow one or two views before my guest. Like I said, one of such interpretations of the Supreme Court's interpretation of the declaration of state of emergency in Rivers State. So it's time for you to alert me. 0817-923-0002, 0817-923-0003, and 0817-923-0007. Let's start with the school. 92.3 Nigeria Info. Good evening. Welcome. Anybody home? All right, let's move on. 92.3 Nigeria Info.
Kalada.
Yeah.
This is Lawson.
Lawson, welcome.
Calling from Negua. You see, the 2004 judgment, this matter. This time, Supreme Court said those that went to court do not have jurisdiction and do not have power or right to take
locus. They don't have locus.
He said what?
They don't have locus.
Good. Now, in that 2004, they told that Joshua Darie went to court, Plateau State, and he was told they stopped that matter because they said he has been suspended and therefore he doesn't have that standing to take the matter to court. So the question I'm asking is, who then, during this emergency, can take this matter to court? That's my first question. And then secondly, other lawyers, the very senior, even stand them, are saying that the Supreme Court actually affirmed the power of the president and the discretionary powers Why is the lawyer in the studio now saying that the Supreme Court did not say so? I don't know. Why is it that lawyers do not agree on anything? They give different interpretations to things. Is the second question I'm asking. Thank you.
All right, thank you,
Kalada,
Lawson.
I don't know if I can just quickly answer his question so that maybe let me
okay.
just put this to rest.
Okay.
Okay, at page 8 of a Supreme Court judgment, see what it says. Section 305 of the Nigerian Constitution does not expressly confer on
That's a certified true copy, yeah?
Yes, certified true copy.
Okay.
Does not expressly confer power on the president to assume or temporarily displace executive or legislative institutions of the state. That's what the Supreme Court said.
But so, is that not contradictory? And that's even my confusion, because if it says that in page 8 of that judgment, and then goes ahead to say the president has got discretional or discretionary power when it comes to extraordinary measures, then it just contradicts, because removing democratic structures could also be discretional.
No. See what the Supreme Court said about extraordinary measures. Extraordinary measures is the state of emergency. Because that's actually at page 7, where the Supreme Court said, at the same time, the Constitution recognizes that extraordinary situations may arise in which the normal machinery of governance is in peril. So the extraordinary measure that the Supreme Court was talking about is the state of emergency. That's something that, Mr. Kalada, you have a right to freedom of movement.
Okay.
That's number one. Let's take it from there. Now, that right to freedom of movement means that you can walk at any Port Harcourt to Lagos, you can travel from Dio to town, to Agri Road, to Peter the Road. You have that right. But once there is a state of emergency, that right can be restricted. That itself is the extraordinary measure.
Right.
The extraordinary measure does not mean dismantling democratic structures, which is what I just read what the Supreme Court said in page 8. That the president does not have the power. The Constitution does not confer on him that power to dismantle democratic structures. Right. So any other thing you see outside of this is not the judgment of the Supreme Court.
Okay, so I'm going to read this message. The summary of the Supreme Court's opinion on the Rivers State matter. The Supreme Court said on grounds of extraordinary measures as stipulated in the grant nom, the president has discretionary powers to suspend, but should be temporarily for a short period under the emergency rule. I wonder where your guys got the idea of dismantling from. In English language, dismantle synonymously means to dissolve something or an institution. This was not the case in Rivers State, but they were dismantled. There was no governor, for a period of time, if you like.
But the Supreme Court never said so.
But I'm going somewhere. Let me read the message completely. He says, what we have was suspension of the executive governor and the legislative arm of government, and the Supreme Court did not affirm the additional powers of Mr. President to suspend temporarily under emergency rule discretionarily. Nobody is talking about dismantling. It's suspension. In other words, suspension and dismantling are different things and arguments. I guess his argument is about the choice of words we chose. But I've got a commercial break.
Semantics.
Yeah, semantics, of course. Can we summarize, because I've got a commercial in about 60 seconds. So your final take on this very issue, please.
My final take on this is very simple. That why the decision, the pronouncement of the Supreme Court may not necessarily be a decision made on the merit, but politicians, especially the president in the future, will now know that Section 305 does not confer the president the power to dismantle democratic structures. And that in the future, we hope that the Supreme Court will be able to give a liberal interpretation to this and not technical, in such a way that states that are not necessarily affected can go to court and seek an interpretation of these kind of issues.
All right, thank you very much, Godspot. It's always a pleasure having conversations with you. And you try the best to make it controversial every one time. Thank you very much for your time. And do have yourself a wonderful evening.
Same to you, Mr. Kalada.
All right, then. Do stay tuned if you are